speaker is Kris Van Opdenbosch, has joined us remotely from Belgium, and his AGN, contact point, Federal Public Service Justice, Directorate General of Legislation, Central Authority for International Cooperation in Criminal Matters. So, Kris, if I said it right, it's okay. If not, please correct me. So the floor is yours, Kris.
Thank you. Hi, everyone. Some of you might know me about the Europris expert groups, which I share since 2 years. And some of you may also know me about the METIS project. Normally, it's our French and Dutch colleagues who are cooperating with Belgium. So I'm working since 1995 at the Belgian Ministry of Justice. And today I will try to give you an overview of our practical topics in the execution of the Framework Decision 909. First of all, the Council Framework Decision 909 has been implemented in Belgium through our law of 15 May 2012. And also I would like firstly to emphasize that contrary to the most of your countries, in Belgium, there is no court which intervenes into these decisions in Belgium. It's more of an administrative procedure, and if Belgium is the issuing state, so it is the Ministry of Justice of Belgium, so the Central Authority for International Cooperation in Criminal Matters, who is dealing with voluntary and also compulsory transfers. So we have access to the database of the Directorate General of the Penitentiary. So in this database, we can screen all the prisoners who are in the conditions to be transferred on a compulsory basis to their home country. Before we send the judgments and the certificates, we do have to consult the public prosecutor of the place where the person is detained to see if there are any contraindications for ongoing investigations or other legal proceedings. If the person is not detained in Belgium, so if the person is already in his home country and we want to transfer the execution of a sentence, then the public prosecutor of the district where the judgment was pronounced is competent. First of all, I would like to say that in Belgium, contrary to our French colleagues, for example, we have no sentence reduction mechanism. So no days are taken into account for any reasons like grace, as we say, or our mechanism for early release is rather simple. We have a provisional release in light of expulsion. This is only for foreign detainees. So they are in the conditions to be released after 1/3. This 1/3 is also taken into account for conditional release for Belgian detainees or residents. But this 1/3 early release is only theoretical because it's an independent court for execution of sentences which decides about the early release. So studies have revealed that most detainees in Belgium are released after the half or 2/3 of the sentence. All our prisoners in our prisons, they receive, the foreign prisoners, they receive an information brochure in Dutch or French. That they have the possibility to ask for a transfer to their home country. Now, we have been evaluated in the beginning of 2020 by the EU, and one of the recommendations was that we should make available this brochure into other languages because we have lots of foreign prisoners, so that they don't only have to rely on this Dutch or French document. So as I said, the central authority can start the procedure for a compulsory transfer if these persons do not have any longer a permit stay in Belgium. In Belgium, we think that even if this decision of deportation is not in the judgment, that the framework decision foresees the procedure, but then we have to send a copy of the deportation order together with the certificates. One important thing is that if the person who has asked for his transfer, he has to be heard. He has to be heard by the public prosecutor of the jurisdiction of the place of detention. He informs the sentenced persons about the speciality rule, because a lot of prisoners, they don't understand this rule of speciality. There is one exception, that in our Dutch-speaking region, this information is usually given by the director of prison, because we had some issues about extracting prisoners from the prison, bring them to the prosecutor's office, and then bring them back just to fill in the Annex 1 of the certificate, which is the form that the prisoner can notice his observations. Now, some practical information about the certificates. When we issue a certificate, we have translated the whole certificate and also all the judgments. There has been some discussions in the past about the judgments that we can have translated the essential parts, but in Belgium, we think that we should translate the whole judgment. And also an important topic is that we issue one certificate in cases where there are multiple sentences. And this reason is because otherwise it's too difficult to determine the early release dates. So these discussions are still ongoing, and also the recommendations from the EU are that we issue multiple certificates, but in practice it's not that easy. So for the moment we continue to issue one certificate. Now, when Belgium is the executing state, then all the certificates should be addressed to the public prosecutor of the district of Brussels. The Belgian law choose to designate the public prosecutor in Brussels because most of the transfers to Belgium, they are executed by airplane. So if a prisoner arrives in Belgium by plane, he will be heard by the public prosecutor in Brussels within, I think, 48 hours now. So prior to the consent of the authority of the executing member states, when it's required, then the Belgian central authority has to give his consent for forwarding the judgment and the certificate. So that is then the central authority of the Ministry of Justice. Regarding the certificates, Belgium accepts certificates in French, Dutch, German, and English. Okay. So for the proceedings, we are a small country, but you see we have several languages, national languages, and then we also have the Brussels district, which both Dutch and French are accepted for proceedings. Normally in Belgium, also a defendant, he can choose his language in legal proceedings. So even in the Dutch-speaking part of Belgium, a person can choose that the procedure is held in French, for example. As for the sentence, a judgment procedure, normally there is no adaptation only if the sentence exceeds the maximum penalty in Belgium for the same offense on the Belgian law, or if the sentence is incompatible with the sentence for the same offense also on the Belgian law. Another specific feature is the speciality rule that so only if the prisoner has announced entitlement to the speciality rule with regard to specific offenses preceding his or her transfer before the competent judicial authority. So this is also a recommendation of the European Union that we should ask the prisoner about this speciality rule. But it's not an easy topic because as I said, most of the prisoners, they don't understand this speciality rule. As for the double criminality check, so in Belgium we don't check the double criminality except for the 32 offenses, so we only check for other offenses. As for the time bar, we had some problems to execute some certificates because there was prescription. So then the prosecutor of Brussels, he cannot accept the certificate. Also, some member states have difficult calculations on the sentence. So that gives problems to our prosecutor, and also the grounds for interruption or suspension. So this can be temporary surrender or extradition to a third party of the European Union. So these are cases which occur sometimes. Also, the criteria for the sentence is the sentence must be final and contradictory. So we don't accept sentences in absentia. As for the sentenced person, before a person is to be transferred, we make assessments about his residence in Belgium, also about his language, and also the social, economical, cultural, and family links. They are really important. And also the prospects of social rehabilitation in Belgium. Now, we have this authority in Belgium, which is called the Houses of Justice. And before someone is to be transferred, this House of Justice, they will have an interview with the family of the detainee in order to determine if he's still welcome in his family, because it happens that families say, yeah, our brother or our father has committed offenses and we don't want to deal with him anymore. So this happens. Also, the age of the sentenced persons is important because for minors, we will refuse the transfer. So, especially with France, our prosecutor in Brussels, he is taken into account these sentence reduction mechanism, but only for the period before the transfer. Once the person is in Belgium, he won't take into account anymore the specificities of the France system. So also here our sentence management mechanism are mentioned. So again, 1/3 for early release, for provisional release, and conditional release for Belgian detainees. Now, the early release or provisional release in Belgium often is granted by the prison manager, and also the Ministry of Justice is competent for early release when it concerns sexual offenders or acts of terrorism. So the early release is automatically granted for sentences under 1 year, and for sentences over 3 years, then the court for executing of sentences is competent. As I said, the houses of justice, and in particular the justice assistants, he is in charge of the social guidance and regular supervision of the person who has been released. Here I have again, so the provisional release. Yeah, there's one change possible. The court for sentences, for execution of sentences in Belgium will probably be released, will be cancelled, and so there will be one judge who will be designated to decide about the early release. Sorry. So about the conditional release, as I said, normally 1/3 of the sentence has been served, but as studies have revealed, it has been more after half or 2/3 of the sentence. Also, our courts, they can express a security period who can be imposed to the prisoner, which also have an effect on the date of admissibility to request a conditional release. And also for specific cases or repeated offenders, some dates have been increased to 15 years or 19 years or 23 years. So specific for murder cases and terrorism cases. Now, before someone is to be released, there are some contraindications to be examined. So this can be the lack of prospects concerning the social rehabilitation, the risk of new serious offenses, the risk that the sentenced person would harass victims, or also the behavior of the sentenced persons towards victims, because this is an issue that has been raised multiple times the last years. This is something that we didn't knew before. So the role of the victims has been more and more important in the cases of transfers of sentenced persons. Also, the efforts of the sentenced persons to pay the compensation to the victims is also taken into account. And actions of the sentenced persons may have undertaken to change his financial situation, of course. Now, to end, I have added some statistics. As you see, we have transferred since 2013 about 400 persons, because at the end of this table, there are some countries outside the European Union. And for the record, I can say that we have issued, I think, about 700 certificates when Belgium is the issuing state. So you can see that our most clients come from the Netherlands, Romania, and France. And these are also the countries which cooperate the most in compulsory transfers. So that is an important topic, because the European Union has had some remarks about our procedure, about compulsory transfers, but we have the opinion that the framework decision is foreseeing this transfer, so we apply it. So thank you very much for your attention, and I hope that you have some questions for me, and I will be pleased to answer them. Thank you.
Thank you, Kris. So if you have questions, you can just switch on your microphone and ask. Ja ir kādi jautājumi, lūdzu ieslēdziet mikrofonu.
So if you have any questions, just switch on the microphone and fire away.
If I may.
Yes, please.
Okay, well, thank you very much to the organization. I'm Maximo from Spain, representing the Spanish Prison Service. Thank you to all the participants and to Kris for his very informative presentation. My question is about, you mentioned that when Belgium is acting as an executing state, that Brussels would be the place to receive inmates, mainly by plane. So how much time, or if you have more information of how much time can it take until the inmate can be allocated to its town or area of preference? Let's say I have an inmate here who wants to go to Antwerp, and he's asking when will be in Antwerp, and is there any prison around? How much time will it take there to get there? What's the administrative process to reach his final destination?
Yeah, so once the prisoner arrives in Belgium, he will be placed in a prison in Brussels, where we have 2 prisons and a third who is now being under construction. Once he arrived there, he can apply for his transfer to another prison. And I think it doesn't take that long. I think it must be 2 or 3 months maximum, because the penitentiary unit, they will examine his request, and then often this is accorded. So I think within 3 months he can be in another prison. Yeah.
Thank you, Maximo, for your question, and thank you, Kris,
Yeah.
for answer. Is there any questions? Are there any questions?
Yes, hello, I also have a question. One question is, actually I have 2 questions. First question is, have you received like specific occasions when foreign state is refusing to enforce your request? In general, what are the grounds of refusal? And the other one is, as you are also EGN contact point, how often EGN is contacted, and what kind are the occasions when the requests and assistance is asked from your side? That would be everything. Yep. Thank you.
As an EGN contact point, I often contact other EGN colleagues especially for transit cases. And maybe, as you know, the last year we had a lot of transits, because traveling in Europe due to the COVID crisis has not been easy. So direct flights from certain countries didn't exist anymore, so we had to pass through other airports, and therefore I contacted often EGN colleagues. And as for your question for grounds of refusal, I heard from our Brussels prosecutor that sometimes he had difficulties to determine the period that a person had already served in the issuing state and the period that he still had to execute. So that often was a ground for refusal, I heard from the Brussels prosecutor.
Thank you. Thank you, Kris, for the answer. So we are, if there is more questions, you can ask them directly in the Zoom chat. And Kris, hopefully you can answer in a chat also, yes? Thank you very much.